Hi, my name is Andrew Meinzer of Meinzer Law Firm. Here we take care of people all across California who are planning to ensure that things go as they want when they die or become unable to take care of themselves anymore, who are handling the final affairs of someone else who's died, or who are helping someone else who has become unable to take care of himself or herself anymore. In this video, I'm going to talk with you about the goals of estate planning and how things can go wrong if you haven't done it. A few short videos will follow that will discuss some of the specific estate planning documents. Broadly speaking, there are two goals of estate planning. The first goal is to distribute assets in the way that you want at your death efficiently. Efficiently meaning with a minimal amount of effort, delay, taxes, fees, and other expenses. This first goal is what most of our clients have in mind when they meet with us. Most people don't give as much thought to the second goal of estate planning, which may actually be the more important of the two goals. The second goal of estate planning is to make sure that someone you know and trust will have the legal authority to take care of you if you cannot take care of yourself anymore in the future for some reason. You might not be able to take care of yourself if, for example, you were in a car accident and now you're in a coma. You suffered a stroke, you have dementia, etc. Estate planning is drafting documents to accomplish those two goals. The more common estate planning documents are wills, trusts, powers of attorney for financial or asset management, and powers of attorney for healthcare, often called advanced healthcare directives. Again, we'll get into these documents in later videos. If you don't have the proper estate planning documents in place when you die, then your assets will go or be distributed to people based on the provisions of California law and not necessarily to the people that you want to receive them. And a probate decedent's estate court proceeding may be necessary to do that. Also, you'll have no input regarding who's in charge, and it may be somebody that you wouldn't want to have in charge. A probate decedent's estate court proceeding normally takes a year or two at the least to accomplish. The probate decedent's estate court proceeding will be required if your assets at death total more than a certain amount, and most everyone in California has more than that amount of assets, especially if they own a home. Similarly, if you don't have the proper estate planning documents in place when you become unable to take care of yourself anymore, then a conservatorship court proceeding may be necessary. Again, you'll have no input regarding who's in charge, and it may be someone you wouldn't even want to have in charge for you. A conservatorship court proceeding will last for the remainder of your life. Because both types of court proceedings are a lot of work, take a lot of time, and can be quite costly, there's something that most people want to avoid. Both of these types of court proceedings also are very public. Anyone can review the documents filed with the court and listen in during the court hearings with the judge. That's another reason why most people want to avoid these types of court proceedings. Again, you can avoid all of this by having the proper estate planning documents in place. We'll go over some of those estate planning documents in the next videos.